the next panel discussion, Arbitration versus Mediation, the various alternative dispute resolution in GCC and Asia. To discuss this, I would like to welcome on stage, can we please have all the speakers over here nearby? All right, so for this particular session, I would like to call on stage Tasaduk Wani, Legal Manager at Voltas Limited, Shaharyar Nashat, Senior Legal Counsel, GCC at Engie, Felipe Marquez, Legal Director, IMETA at CHEP, and Selim, Founding Partner at the Law Office of Sariibrahimoğlu. Sir, can you please be on the stage?
Welcome all ladies and gentlemen. My name is Dr. Selim Sarıibrahimoğlu from Turkey. I'm the partner and owner of Sarıibrahimoğlu Law Office. Now we are going to have in our panel Mr. Wani, the legal manager of Voltas Limited. Thank you. And Mr. Nashat, senior legal counsel, GCC. And Felipe, I think Felipe Arboleda-Marquez, legal director of CHEP. So, well, I think the topic is really a hot topic, and it needs to be discussed really more than the time that is allowed in this conference. I have to start with a very practical issue regarding arbitration decision, arbitration awards. In Paris, about a month ago, more than a month ago, there was a discussion, and I addressed a question to ICC chairman and also the General Secretary and all of them. What I said, you know, arbitration as an institution must be in the stage that should provide transparency, and additionally, more than that, it must also create its own predecessent constructive decisions. So this is the most important thing. And I think the Deputy General Secretary, he responded that, well, to create a constructive predecessent decision, even the European Court of Justice could not manage, which was wrong, of course. So at the end of the day, if you want arbitration to be a solution for all the world, all business world, I think it is important that arbitration should have some principles, constructive principles, which can be used as a precedent decisions for the whole world trade. Otherwise, it will not meet the expectations. In any case, why I raised this question, this was something quite strange, and I think for all of you, it's a very unique and very exceptional issue. In one of the arbitration cases, and this case was related to a natural gas plant station. And during the litigation period, although I warned the arbitrator that he should use a technical expert in such a technical issue. And Swiss law was applied, and according to Swiss law, which is the same with Turkish law, I insisted that you need to provide a technical expert, because main questions, I mean 10 questions of the case, 8 of them were technical. And despite that, I insisted, she issued the decision without using a technical expert. And it was really totally technical. It was about the gas leakage and all of these technical problems. So what happened? She issued the award, but I rejected this award just only to give ICC a chance to change their decision, because at the end of the day, it was against, according to the Library of Arbitration, it was against arbitration precedent decisions, how this can be done. So during this rejection examination, it was only for the material mistakes. But unfortunately, the arbitrator insisted on this issue, and now I raised my question that I'm going to file a lawsuit before Swiss public prosecutor, and also additionally before Swiss courts, because we are not applying the rules. This is very important. Now, it is very strange. We know that arbitration award is a final award. No, it's not a final award, For more than 6 months, they are still investigating the situation, and I'm waiting the result, because this is really important. And if they decide that this is the final award, then I think the trust and the confidence to arbitration awards shall go down. It is very clear. So it was told to me by the General Secretary that they are still investigating the situation and they are looking at this issue. But to tell you the truth, I think impartiality of the arbitration awards is really very important. And to my point of view, other than the costs, I will come to that point. Because of these difficulties, there are some solutions on the world. The world is not just waiting for that. For example, I will tell you one short story. The Russian ambassador, he requested me whether we can have a bilateral law which makes Russian commercial court verdicts to be applied directly in Turkey, and vice versa, Turkish commercial court verdicts to be applied in Russia, because there's a really big amount of business people from Turkey and Russia and cooperating in Russia, and many of the construction companies are in Russia. So what happened? We managed the Turkish court judge to accept, to recognize the Russian verdict in Turkey, but it was only a court decision. So at the end of the day, we applied to the Turkish Foreign Ministry and also Justice Ministry, and the agreement already prepared, and it is given to the Russian Foreign Ministry and Justice Ministry to be approved. So what will happen? There will be no need for any arbitration. It is finished. Why it is happening? Because arbitration as an institute is not trying to refresh their main duties. And second, and so this is one of the examples. So this means that arbitration will be not necessary between Turkey and Russia, for example. Vice versa, China already established a new institution with 25 countries in the Pacific and south of the world, and they asked Turkey to be a member. And this mediation association, all the expenses are covered by Russia, and 25 countries, judges can join that, and all the disputes can be solved out without any big expenses of arbitration. So for that reason, I think one of the important issues about arbitration is really the cost. So the cost should, in any case, should be decreased to a level which the justice, fair justice, can be applied. And I can give you an example. I'm one of the members of CEPANI. CEPANI is a new arbitration center which is established by the European Union. So their costs are very low. So when we come to the position of reducing the costs, etc., then I think we may be a little bit away from fair and real justice. This is also another risk. So for that reason, I think one of the main problems is impartiality of the arbitration decisions. Second thing is the cost, but at the end of the day, I see that all of these new solutions is a way of escaping from arbitration, which I believe that it is very dangerous and risky for the whole business world. And I know that in the countries in like Kuwait, Saudi Arabia, UAE, Oman, and all these countries, they already changed their law in order to make arbitration to be available in their countries. These are really good developments, and I believe that arbitration is a good system for the whole business world and trade. But at the end of the day, we must try to do our best to delete the distortion and also pollution on these arbitration decisions. And to tell you the truth, also there is one important subject which we also discussed in ICC meeting last time in Paris. This is the transparency, which I'm saying, because some of the big companies, they say that, no, we do not want to share our company's confidential information. I can understand that, but if we do not have transparency, then how we will maintain a fair judgment? You know, this is also another question. So I think also we see that there are a lot of arbitration centers on the world, in Bahrain, in Kuwait, in all these countries. So I think we have to find some common solutions. Otherwise, it will be like the national courts, to tell you the truth. And we know that the whole world and business, really we need something common to solve all the business problems, because the world is becoming smaller and smaller, and we need fair justice for everyone, you know, in any case. So under that condition, I hope that ICC will be able to solve these problems which I raised during Paris, but it was not possible to get real answers. But regarding technical expert, I think it will be a good practicing example for everyone. So these are the things that I would like to point out, but of course during questions you can always raise your questions, and also we can exchange our ideas. To tell you the truth, I will tell you something. You know, in these kind of meetings, it is very important to give time to the questions, to the real questions. I will give you one example. Regarding turnkey projects, there was a discussion how we can claim the things which is done later, you know, just during the turnkey project. So there was a question, and then I attended one of the FIDE conferences and also arbitration conferences in London, and there I asked this question, and I found the answer, and I won the case while discussing with the whole audiences. So I think in arbitration especially, we need the whole mind of all the lawyers, legal people, and engineers who are involved with arbitration, and to get their opinion, and it will be really, really very useful as an example. So now we are coming to the panelists. First question to Mr. Nashat, and please just introduce yourself and how the use of technology is or will impact the selection of the use of either arbitration and mediation as an ADR methodology.
Sure, thank you for the opportunity to speak on this topic, and hi everyone. I think the use of technology and how this impacts which methodology we would use, or the choice or selection, it's becoming more and more important and more relevant as we see the jump in technology, the transformation for any dispute resolution methodology. But when we talk about specifically ADR, there are two themes we need to keep in mind, and I think you mentioned them already, Mr. Selim, which were transparency and impartiality. And within that sphere, you need to keep in mind there's the legal impact or legal considerations as well as practical considerations. From my perspective, you know, when we look at legal considerations, there's obviously the first and foremost, does your arbitration agreement or your mediation agreement or your ADR agreement, does it actually contain the relevant provisions, the language that allows for the use of technology to conduct the dispute resolution mechanism using technology? For example, does it allow the use of telecommunication devices? Does it allow the use of a artificial intelligence program to be the arbitrator or mediator? Does it allow deep learning algorithms? Does it allow e-discovery? And then also, you need to bear in mind the seat of arbitration or mediation. The jurisdiction that you are based in or the jurisdiction that you have chosen as your seat, does that allow the use of technology for the ADR methodology that you're opting for? So those are some of the, not all, but some of the legal considerations you would have in mind. From a practical consideration standpoint, there are things you need to obviously consider, such as when you look at employing various technological methods that are available, can you employ those without compromising something you mentioned, confidentiality, trade secrets. When you look at e-discovery, how would you define the scope? Because the program that you use is going to work within those parameters. What about the variables that exist that program, whether it's AI or deep learning, or if it's just a simple search tool, can that utilize or can that work within a framework of those variables and pick those out? And also, it's not so simple as, you know, when we talk about, for example, Chat GPT, which is quite popular nowadays, and it's the buzzword, just like, you know, ESG, what we were talking about earlier. It's not so simple as just plugging in or putting in a question and you're going to get the right response. It's about knowing the right question to ask, and then extrapolating the answer you need or the data you need from the data dump that it gives you. So you've got to bear that in mind as well when opting for and looking at which methodology to use and how can technology help you, and which technology or programs or platforms can you use. The other thing that, you know, from a practical standpoint, obviously one would bear in mind is costs. Obviously, in this day and age, cost is something that we all have to be very aware of, we have to be mindful of. And of course, we've seen in the last 5-6 years, you know, ICC, under the ICC rules, under the UNICITRAL rules as well, they've amended those rules. They've allowed greater use of technology, telecommunication devices, video conferencing facilities for presentation of witnesses, evidence, for the hearings, the actual hearings to take place as well, for using those platforms. So that's, of course, helped to cut down the cost to a large extent. Now, going forward, can you employ other technological platforms to reduce costs further, to bring about greater efficiencies? Because we know that while mediation is a relatively informal process, there's a lot of human judgment involved. So is that something that a learning platform can actually substitute? Arbitration is a more formal proceeding, so that's something where, you know, potentially you see AI intervention, because we've seen that there are jurisdictions in Central Europe, in other parts of the world, in Southeast Asia as well, where AI is being used as a dispute resolution mechanism for litigation, for example. So can efficiencies be brought in from that perspective? Arbitration, we know, of course, because of its formal process, now does take a bit longer as compared to other ADR methodologies, such as mediation or negotiation. So can technological intervention bring that timeline down? Can it bring in more efficiency? Those are obviously considerations you need to bear in mind. Keeping in perspective at all times the peculiar circumstances related to your particular agreement, the transaction at hand, and the dispute as well, the nature of it.
Mr. Nashat, I mean, it's very valuable what you are saying. Now, I'm curious of asking one question, which we were really thinking about it during pandemic period, when we were handling an arbitration issue. So, since I know that you know really a lot and deep in this field, can I ask you a question which was asked to me and I rejected, whether the visual hearings in arbitration is the one that you prefer or not? Which one? I mean, I agree that to collect the evidences, to shorten everything, you know, to use technology, but do you agree a visual hearing instead of face-to-face hearing, you know?
So I guess I should have given this caveat before. You know, all views and opinions expressed are my own personal and do not at all represent the views of my employer, Engie. On a personal level, I'm old school. I like human interaction. I like being there physically, face-to-face, because I think there's of course what you say and what you can hear, but I think the body language, there's you know, unheard language that is spoken at these hearings as well, just like you see in litigation, arbitration, mediation, whichever forum or type of hearing there may be. So I prefer that because I think that says a lot, and that that gives you a lot more insight towards what direction the hearing is headed in. So I prefer physical over electronic.
Well, thank you very much, but I will advise you in a very important meeting, one of the lady lawyers from our office, during visual meeting, she observed that the other party's lawyer is not telling the truth because of her body language, because in the visual you can easily understand it, but as males we cannot, but women can understand it. So this is also another advantage in that, which I met practically. Okay, then Felipe, other business implications of arbitration and mediation from an in-house counsel standpoint. Before explaining, I really rely on in-house lawyers. When I'm dealing with an arbitration case, I always use the in-house lawyers and their information. It's always my doing business in this way. In Turkish, we have a saying, if you want to catch the rabbit of the local, then you have to use the local greyhound. But unfortunately, usually the outside lawyers, they are, for example, winning the arbitration and getting the arbitration award, but they disregard in-house counsels really support to that case, but I'm not that type. So I think this is an important issue for the in-house counsels, to tell you the truth. But sometimes in-house counsels are saying, look, lawyer did nothing, we did everything. So please kindly try to explain these issues when you're talking.
Sure, and maybe I'll start a little bit with the background. So yeah, as mentioned, I mean, I'm clearly an in-house lawyer, and I've had the opportunity to work not only in this region, but also in other emerging markets. So my background is actually South American, but that has actually given me the opportunity to see, for example, arbitration in Ecuador and mediation in Brazil. And now that I'm in this region, I can actually compare a little bit. I've also had the chance to have a mediation. Actually, I just got an email about a mediation in Botswana, which is a little bit crazy that you can set some comparisons and some similarities between regimes, even if you're in the other side of the world. So from that perspective, in my career, of course, I've been a little bit in the background. So you as an in-house counsel, well, you're always deciding, but at the same time deciding not only what external counsel you're going to use, but also doing a second part of the process, which is negotiating internally. Not only you have, of course, a negotiation with the third party in case of a mediation, but also internally you have to negotiate with your own stakeholders, your presidents, your finance managers, your shareholders, depending on the structure of your company. It's a second mediation, if you will. You have two negotiation processes, one outside and the other one internal. So I guess I wanted to share a couple of thoughts around what makes a good, let's say, strategy or a good dispute management system from my perspective. And I've been a little bit, depending on the company, you could have different answers. There's no one answer that fits every single company. So in my experience, I've seen the big multinationals. The big multinationals have very robust dispute management systems or protocols or processes, if you can call them that way. And those companies, in my opinion, they're very, very rigid. So if you have a US-based multinational, they would usually have a very robust process, a very robust system that would say, let's say, every single affiliate would have to agree to arbitration in a, let's say, international hub, being Switzerland, being London, being in some cases even Delaware. I've seen that in big multinationals. That, in my opinion, doesn't really help. And to your point, if you're a company based in Dubai or based in Istanbul, well, going all the way to Delaware to litigate a small claim, it's absolutely crazy, in my opinion. But sometimes these multinationals have these dispute processes and sometimes are mandatory. Then you have kind of the local, relatively big companies that maybe not multinational, but are more local. Those have a little bit of flexibility, and sometimes they don't even think about having a dispute management system or some sort of protocol in that sense. And they're asking those questions. I mean, what should be that system? What should be that procedure that we have to implement? And those are the ones, I guess that's the sweet spot where you can actually add value and say, listen, in your circumstances, your best dispute resolution or mechanism or procedure should be this or that, maybe favor mediation, maybe favor arbitration, depending on the circumstances of the business. And then I guess the third tier would be your startups. Your startups are very, very, unique in the sense that they don't even think about these things. I mean, these things are absolutely something that it's way, way beyond their actual business. And in those cases, they usually end up in court, and they don't even, and that's also an area where in-house counsel, at least, and external counsel, to the extent that they need it, can also add value. There's also one other thing that I wanted to mention. I mean, some companies have the conscious decision not to have a policy. And that's also a policy in itself. Have a conscious decision that we will deal with every single dispute on a case-to-case basis. So if a dispute has to go to court, we go to court. If a dispute comes in and we think arbitration is the best mechanism, then we will agree to an arbitration agreement, depending on the case. I've seen that those policies too, and in my opinion, they can also work quite a lot depending on your type of business. So I wanted to kind of give that a little bit of context from an in-house perspective. And in top of that, in my in-house experience, I've seen another debate to arbitration or mediation that falls a little bit away from the usual legal discussions. So we all talk about costs, we all talk, of course, about, let's say, transparency, enforcement, those usual legal topics that we saw not only in law school, but we see it across our careers. From an in-house perspective, I think there's a couple of other things that you also have to take into consideration that I've actually came to find out way later in my career. The first one I wanted to mention, because I saw it very recently, so I thought it was good to bring it to this forum, is insurance. As an in-house counsel, insurance, and it's a big factor that companies take into account before making the decision between arbitration, mediation, or even going to court. Just to tell you a story, the company was very comfortable with heading towards arbitration with a vendor. It was a very complex dispute, one of those that a local court would probably find very challenging, would have taken too long, and the decision at that point with external counsel was, let's go to arbitration. This is much better. The other side also wanted to take the case to arbitration. And after negotiating, having an agreement or an agreement in principle, some finance guys came in and said, well, actually, our insurance policy does not cover arbitration. Insurance policies actually only cover awards that are given by a local court. And well, without going into the details, insurance companies had some requirements in that case. So after burning my fingers, I guess, I wanted to kind of bring that to the table. It's not something that you would usually get told in law school, and it's not usually something that you are very mindful of. In my opinion, it's actually now one of my key priorities. Ask insurance first. That's one takeaway that I wanted to share here. The second one is on financial accounting or financial contingency accounting. That's also a big one because, again, judging from experience, depending if the company makes the decision to go to either arbitration or mediation, the accounting of the contingency, depending on the accounting principles that the company follows, might differ. And that difference could be massive. So if you go to a mediation, or the company goes to a mediation, usually that contingency is not necessarily accounted for as a contingency yet. Because mediation, of course, it will depend on what you reach, what type of agreement you reach, but it will never be enforceable, as everybody in this room knows. And in that sense, the accounting of that potential contingency is not necessarily recorded and could have a different impact in your financial statements than if you start either a mediation or a court procedure, which is usually in favor of mediation. And you would try to lean towards mediation because the impact, you could eventually defer it, or at least, depending on your finance procedures, you can account for it differently than arbitration or a court case. So that's kind of a second factor that again, at least in my opinion, it's not your typical legal discussion. And then the third one, and I close with this, is internal resources. So again, we're talking a lot about cost. Usually arbitration is much more efficient than going to court in general, and mediation is even more efficient. But the internal cost that takes to go to mediation is actually much higher than going to arbitration. And let me explain a bit why. In a mediation case, you actually have to involve your team. You have to produce evidence. It's not a regulated procedure where you know what you have to do. Your external counsel will tell you, this is what we need, these are the witnesses that we have, this is the procedure that we have to follow, this is the date. In a mediation, it's a little bit free, let's say, and it demands much more from your company to try to produce that evidence, to try to convince the other side, to kind of make the mediator understand what you really want. In my opinion, requires much more internal resources than an actual arbitration, and it's a little bit counterintuitive that mediation could cost you more in terms of internal time and resources than actual arbitration. So that's also kind of a factor that I've come to see with my experience. So those are the three that I wanted to share. Well, more than welcome to receive any further questions.
Thank you very much, Felipe. I think this was very informative. But since you are Colombian, and as I told you, I was the first chosen Colombian honorary consul for Turkey, you know. But luckily, I was lucky because they decided to establish the embassy, because at that time they told me which part of Colombia you're going to be the honorary consul, the government side or the other side. I said government side, then just put $100,000 in your pocket and go there. So luckily, embassy was established and I saved it. Actually, Felipe, here, I want to ask a personal question, because I'm working with a lot of in-house lawyers in many companies in their international disputes. I'm sure that some of you are in the same position. What is the best way to approach the in-house lawyers in this kind? How we can get their heart, how we can get their confidence, how we can get their mind in this issue? What is the best way as an outside counselor in order to be able to get the best help of the in-house counselors?
I'll give you my personal opinion, and
Yes.
Depending on the in-house counsel, they might have different opinions. But my personal view is building a relationship of trust. It's not necessarily the best litigator. It's not necessarily the least, let's say, the cheapest. It's rebuilding a relationship where you can pick up your phone and call your lawyer and say, we're in the middle of this thing, how can you help me? And the other side can simply reply and say, I'll be right into it, or my associate will get into it. That's, for me, the key element that a litigator in this case would have for my lawyers. That's what I expect. If it's a very robust firm, that if I give them a call, no, listen, you have to wait, the partner is actually very busy, we'll get back to you in 48 hours. That's in our experience in my company and my personal one, is not the law firm that I want to work with.
Okay.
So if I can also just add to what you said,
Yes.
Felipe, and as an in-house counsel, I completely agree with that. And I think my 2 cents on this would be, adding on to exactly what you said, is I want, from my external counsel, what I'm looking for is the relationship of trust and building a partnership. Because you want your external counsel to feel, of course, not feel the pain, but understand your position and understand the urgency or the need and prioritize certain matters over others. And you don't want that it should just get stuck in the line and then it's sort of chugging along or moving along. You want the external counsel to work with you as a partner in helping resolve whatever dispute you've got in hand.
Okay, Mr. Wani. Now it's your turn, and we would like you to talk about whether mediation and arbitration should be adopted as 2 steps for dispute resolution, or one should be chosen for the other. What are the possible risks posed by the combination of mediation and arbitration? What are the key advantages? If you can simply state about this, but I want to say one thing for the audiences. I think most of you are Indian origin. I'm also a bit Indian because I served for the Indian embassy for more than 25 years, and I'm handling the most corrupted case of India for more than 20 years, NFL case. So I feel myself a little bit Indian. Thank you very much.
Thank you very much, Dr. Salim, for this question. First of all, it's my pleasure to interact with all of you here. Before taking this question, I'll take a step back and try to briefly explain here these two concepts of alternate dispute resolution. When we say mediation, it's a type of an alternate dispute resolution wherein a third party, impartial, a trained mediator engages with the disputants and tries to settle their disputes with their consent. And when we say the arbitration, it's again a type of an alternative dispute resolution wherein equally third party, neutral, and trained arbitrator resolve the disputes between the parties. Now the key word for a mediation is the disputes gets resolved, the disputes get settled with the consent of the parties, and in arbitration it gets resolved wherein at the final resolution the parties will not have anything to say. Now answering Mr. Salim's question, taking up these two mechanisms together, it's called MEDAP. Have anybody heard about this type of a dispute resolution mechanism? Okay, let me explain it a bit. MEDAP is a lesser known this alternative dispute resolution mechanism wherein the parties agree for the two-step dispute resolution mechanism. The first one is that parties has to indulge into a definite mediation, and when it will become failure and it will not get any success, only then they will go to the second step for resolution through resolution through arbitration. Now, so far as the pitfalls of this MEDAP is concerned, to my understanding, the first and foremost thing is that there is an apprehension of breach of confidentiality. As we know that most of these mediation laws, they are protecting this, they are protecting the confidentiality of the parties, even though that is there, but one can understand the state of mind of a party who is involved in this mediation when the party has to reveal to the mediator all the details pertaining to their dispute. There are every apprehension that the details, if the process is tomorrow goes for an arbitration, these details may be backfire him, and that will turn into a negative for his interests. So that aspect of it may keep this party stepping back for a success of this mediation process. That's one thing. And second thing is that prima facie, when we see these are the two-step process, which one can say its cost would be more, resource needs to be more, it will consume more time. So these, to my understanding, are the major two concerns that which prevents the parties to agree to this kind of a dispute resolution mechanism.
Thank you very much. Is there any question that you would like to ask for three of you among each other? Do you have any questions?
Since we were talking about artificial intelligence and how could that influence arbitration and mediation in this case, do you think there's going to be the moment where artificial intelligence will be eventually a mediator or an arbitrator? Do you think we will reach that point?
I hope not. No, I think, on a serious note, I think that I think we're not too far away from that point in time. I think that when you look at arbitration specifically, one of the concerns nowadays with arbitration is that when you choose something like the ICC rules and you choose ICC as the venue and you have your seat and whatnot, one of the concerns is that arbitration has now started taking longer than it previously used to be. You know, I remember maybe a decade ago, it was said that arbitration takes anywhere up to 6 months. Now it's said that arbitration takes anywhere up to 1 year. and you have new rules coming up in terms of discovery rules as well, and you have to make green discoveries, e-discoveries and whatnot, which has complicated the process, but also has lengthened the process of arbitration as well. So when that happens, you have to go back to where did ADR or the different methodologies or concepts of ADR actually come from? It was because litigation was just taking too long. That was one of the criticisms of litigation or going to court, aside from the forum and jurisdictional issues. So going to that, when you see that arbitration is now taking longer, so parties will start looking at efficiencies. Parties will start looking at tools or mechanisms. How do you shorten the length or time? And AI is something that, you know, is now being presented as something that can actually shorten the timeline, the time frame. You know, I was reading last year, I think it was one of the Central European countries ran a pilot program where, not for arbitration, but for their lower courts, you know, we're dealing with matters such as traffic violations and whatnot. They plugged in an AI program to resolve those, where claimants were coming and appealing them. And the AI program resolved issues that were taking anywhere between 6 to 9 months. It resolved them within 1 week. So if you sort of extrapolate that and put that in an arbitration setting, you know, I think time is not too far where when AI, an AI platform could come in and supplant, you know, human arbitrators. I think as far as mediation is concerned, I think that I find is probably a more difficult proposition, because mediation is more judgmental, it's more subjective. In mediation, it's more about compromise between the two parties, and it's about trying to find a middle ground where it's actually the two parties, and the mediator, like Tasaduk was also saying, is more of a facilitator as opposed to an adjudicator, which happens in arbitration or litigation. So, but let's see, I think, you know, times are changing and things are changing very rapidly, so it's very difficult to see where this goes.
Well, thank you very much. I think regarding artificial intelligence, whether it can be converted into a legal system, I think first of all we have to find a way how to control the artificial intelligence before using in law, because there are certain risks, I mean, which should be avoidable. I think we have a short time, but I think we can get one or two questions from the audiences. So please. Shall we give the microphone to him?
Audio? Hello? Yeah.
Hello. So this is Salman Ahmed, and I'm working for a group of companies in an IT.
Can you speak a little bit loud, please?
Okay. So this is Salman Ahmed, and I have been working for a group of companies, an IT-based group of companies. Okay. So I'm talking here with respect to the in-house counsel's perspective.
Okay.
That how can we go about, and can you please put some light on the enforcement of the mediation decision of the mediator and the award of the arbitrator? Number one. And there is another question which I would like to ask simultaneously. This is specifically from Mr. Felipe, please.
Thank you.
Yeah. So that is how are the costs of mediation like higher than the cost of arbitration? Because the evidences which you referred to, like those are required in both the procedures. So can you please put some light on that? These are my two questions. Thank you.
Thank you.
So far as your first question is concerned, when we say mediation, mediation does not turn into an award. It turns into a settlement agreement between the parties. When the parties have finally reached to the conclusion that the particular settlement works for them, then this mediator gets them agree on a particular settlement agreement, and that settlement agreement becomes binding on them. Now, so far as the arbitration award is concerned, so far as we know in UAE, the arbitration award can be easily implemented, can be easily executed through local courts. As we know that this jurisdiction is a friendly arbitration agreement, we will see there are very less chances wherein the court entertain the nullification proceedings. So the remedy for against the arbitration award is a nullification proceedings. The grounds for nullification are very limited, which goes through the public policy and all those kind of things. And the tendency of the courts, particularly in this jurisdiction, it's arbitration friendly. So I have not seen in my span of 10 years over here that any of the arbitration award was not allowed or the courts failed to execute it.
Okay, is there any other question?
I guess the second question, to answer the second question, so in my view, mediation ends up costing more in terms of internal resources than going to arbitration, but it's a matter of internal resources. And let me give you an example to kind of explain what I'm saying. When you do a mediation, the resources that the company has to invest in terms of producing evidence, going to the hearings, trying the other party to understand your point and your standpoint, it's, in my view, it's much higher than when you go to an arbitration. You just hire external counsel. There are set rules. External counsel tells you what to do. It's very structured, and from a financial standpoint, you already have it outsourced. So nobody has to, it's probably in-house counsel, maybe some witnesses, let's say, producing some evidence that external counsel will take care for you. But mediation, since it becomes so complex and it's a matter of convincing the other side of your views, producing evidence that the mediator can also understand without any formality, in my opinion, and the mediation process that I've seen, it demands much more resources from the company than actually just hiring a law firm, dealing with arbitration and the process. So in that sense, I guess the takeaway is that mediation is not necessarily much more cost efficient because it will demand much more resources from a company.
Okay.
Thank you so much for the clarity.
Please, there's another gentleman over there. Well, the questions were really good, and the answers are also very efficient. Thank you.
Thank you so much. Very, very informative. I just had a question. My name is Kriyakus Verghese. I'm a lawyer practicing in Delhi. The first question is this. The way I see it, mediation, I beg to take a contrarian viewpoint. The Singapore Convention, which has just come in 2023, is going to make mediation enforceable as a decree across borders. Now, this is in consonance with the United Nations international settlements. Now, since the convention comes in, we all know that UNCITRAL started off first. So you have the New York Convention and the Berne Convention, and of course, arbitral awards are enforceable. I understand that it can be a little problematic. But mediation also has institutional mediations now coming up, which means that you have specific centers for cross-border disputes, where mediation could now, probably, I understand each of us have a very different perspective in terms of our life experiences. But internationally speaking, the law today is crystallizing in favor of moving towards some level of mediation as probably the first step before you trigger arbitration. So you explore mediation because essentially businessmen need stability. The rule of law has to be stable. It has to be transparent. And for businessmen to move fast, they need immediate resolution in terms of rule-making powers. Mediation is informal, and then I think, Philip, when you're explaining it, I understand that, as far as big firms are concerned, there is a step-by-step process which makes it easier. But sometimes cultural issues also crop in, and I think trained mediators probably can be the answer in the future as the world integrates more rapidly. This is just my take on mediation as well.
Excuse me, your question, please.
The question is this. The question is whether mediation at the end of the day can be utilized by GCs going forward in a more proactive manner.
Thank you very much.
Just to answer your question, as we know that the mediations are now getting more regulated. More regulated in a sense, if we just have this UAE perspective. In 2021, we had here a law pertaining to mediation, which we called Federal Law number 6 of 2021, which has regulated the mediation in a sense that there are various safeguards, as the safeguard of without prejudice defense. That has been really protected over there. If we are revealing anything to the mediator, so that will not be used against you during any subsequent proceedings if it will not be successful. Now the question here is one has to see how the things would be beneficial for him. Now the one important aspect of going for mediation is that it's pro-business aspect of it. Suppose when we go for the disputes, its first repercussion is that the business relation between the parties gets strained. It will be in rare cases that the parties will go for the business in future in any such event if they have to contest the cases. If there would be disputes which will go for arbitration, it would be very rare because that trust deficit lacks there. Now, on the contrary, if we just see that your disputes, because when it's a business, disputes are bound to happen, but if somehow you are managing your disputes in such a way it's getting resolved amicably, there is always a win-win position. So when we consider that part of it, we'll see that it's not only the present dispute, it's our future business aspect that's getting protected through mediation. The only thing to my understanding is that at the very initial state, at the state of negotiating your agreement, one should understand his position to frame the dispute resolution clause or to frame the dispute resolution agreement in such a fashion so that one could take these steps together. One could say these steps one after the other. And if there would be in every this circumstances, it will be beneficial for both of the parties.
Well,
So I'll just add something very quickly. My personal view and my experience has been that in business, in the business community, in the corporate world, wherever you go, whatever country you go in, relationships are more important than winning some small dispute or whatever, right? So building relationships and preservation of business relationships is extremely important. As an in-house counsel also, that's something that you always bear in mind. And mediation as a tool gives you that ability to maintain or preserve certain relationships even when a dispute arises. Arbitration, on the other hand, is a lot more adversarial, just like litigation. So that is something that you always do consider, that's something that you always bear in mind when deciding or looking at what tool is more beneficial or what tool you want to use for dispute resolution. Similarly, there's, it's not a topic here, but negotiation, again, is an ADR tool that is used as well for the same reason. A lot of companies will have long-term contracts with each other where they're service providers or parts providers or whatnot. And there you might have disputes within the contract, but the overall contract, you want to keep it intact. So for that, again, mediation is a very effective tool.
well, thank you very much. I think we have to finalize our session here because there is a gentleman looking at us with an eagle eye. So, so thank you very much for all of you.